Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm just setting up, so give me a minute to set up. I'm setting up both on Instagram and on YouTube. So give me a quick minute. Let me get this started. All right, so now we're ready to get started. I am U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments. I have a great topic for you today, and it's an important one because one thing I find is people make a certain mistake, and because of that, it causes them not to be able to qualify for employment-based green cards. And so I want to touch on that today and give you, give you some tips on how to approach an employment-based green card. Now, can an employer get you a green card when you're already out of status? The general answer is usually no. If you are getting a green card out of status, when you've been out of status through an employer, it's probably because you have met a certain exception. And even then, it's unlikely that you'll be able to stay in the United States to get the green card. You'd still have to go outside of the US to finish the green card process and then come back in with an immigrant visa. So if you're here now, and you may be thinking about your next step, and one of those is, should I just overstay and see if the employer is willing to apply for you? You need to be very, very careful about this. The first is, when you're going through the employment-based green card process, you're not supposed to be working without a permit in the United States. If you're lucky and you ended up working without a permit in the United States, but you worked for under 180 days, so you didn't go over 180 days of working without a permit, you may have a shot. But once you work without a permit, you're in a red zone and you are risking being denied in your adjustment of status process for an employment-based green card. The other is, if you have an option right now, and you should not be overstaying. You should be evaluating your options. But overstaying is definitely going to kill the possibility of getting a green card through adjustment of status. There are other types of situations where, if you've already overstayed, you may be able to seek relief. But underemployment, if an employer is promising that they will fix your status, if you've already overstayed, there's something going on there. There may be a catch. The employer may not know that they don't have the ability to fix your status already when you've already overstayed and when you're working with them for them without a permit, or they may be misleading you. If an employer has been promising to sponsor you and you're already out of status and you feel like, no, they're taking advantage of you, you may qualify for another type of benefit, but that's where it's important to schedule the consultation. So 2 no-nos when you're thinking about applying for through an employer, especially when you're looking at adjusting status in the United States. That means to stay in the US and apply for the green card. It's, don't overstay your visa. Overstaying, you're not going to qualify for adjustment of status. And don't start working for that employer you're not supposed to start working for that employer until you actually you're approved, or if you're going through adjustment of status, you have your work permit. Anytime before that, you're not supposed to be working for the employer. Applying isn't going to allow you to work for them. You have to actually be approved to be able to work for them, or get a work permit to be able to work for them legally. And when it gets to the interview, that's where you're going to find you're going to face very severe consequences for working without a permit, for the employer that may be sponsoring you, or for overstaying. So those are the two no-nos before you make any decisions, whether it's to work for the employer or to overstay. You need to make sure that you get legal advice about your options, because at that point, your options are going to be limited, especially if employment is the only chance that you have to get the permanent resident. If an employer is promising you that they can fix your status, you should question after, and you've been out of status already, or they tell you, stay, I'm going to get your work permit. You need to look deeper and figure out what the motivation is behind that. What's the motivation of the employer? Because legally, they can't just apply for, let you stay here and then get your work permit for you. If that has happened, get in touch with me and we can talk more about any possible options. So for example, if you're in a situation where an employer, promised you they could fix your status and then made you work for them, and then you found out afterwards that they were not telling the truth, and that they took advantage of you and your labor, there may be, you may qualify for relief under what's called T status. And that's as a victim of labor trafficking. There are a number of requirements that I would have to see if you qualify for, because the purpose of that has to be that they recruited you, they harbored you, they induced you to work with them for fraud, and then as a result, you thought you were going to be working in a certain position or working certain money, and it turned out it wasn't like that. If you're in a situation like that, there may be relief. But otherwise, if you're doing a straight and narrow, straightforward employer type petition to get the green card or get any type of visa, it's not going to involve you staying here without status. Now, I am also here to answer your questions. So go ahead and put your questions in the comments. I'm both here on YouTube and I am on Instagram today. So put those questions. It's been a long time. Well, it's been a few days and it's been very busy. But as usual, I have to come on and check in with you all. And it's nice to see you today. Go ahead and put your questions in the comments. I see a few already. So let's go. I'm going to work through those. All right. Let's see. I want to come to the United States. How do I do it? It's going to depend on, your background, your qualifications. What are your goals to come to the United States? Do you want to visit? Do you want to come temporarily to work? Do you want to go to school? Or do you want to come and live here? Your options is going to first depend on the answer to that question. And then after we determine what your goal is, the next question is, well, do you qualify to come and live permanently? Do you qualify to live and work here? Do you qualify to live and go to school here? Do you qualify to visit? There are different criteria for different, based on your goals and based on your qualifications. That's where, the consultation is going to be very important. It could take me not even an hour, could take me a couple days to talk about those benefits and possibilities. So go ahead, get in touch and schedule that consult. How do I sponsor my boyfriend, whom is also my child's dad? Does us getting married affect him getting his green card? So if now getting his green card, if he's being sponsored by a parent or a sibling, well, actually a parent, and he's showing as an unmarried son of a US citizen or a green card holder, getting married could affect your possibility of getting a green card. But hey, if he has to choose between marrying the mother of his child and getting the permanent residence through the mother of his child or getting it through his parents, it depends, of course, on your personal preferences, all the stages that you are in your relationship. But getting married is going to get you through a faster process if you are a US citizen or a legal permanent resident. However, if you're not here, you're not a US citizen or you're not a permanent resident, then getting married to the spouse is going to affect, getting married to your child's dad is going to affect the process, in that it turns it now from maybe a 5 to 7 year process, and who knows how far he's in now, to a 12-year process. So, that's where it's important to schedule that consultation, because then you learn about those options. If you and your boyfriend are ready to be married, you're a citizen or a legal permanent resident, it may just be worth it to do it that way. So, remember that the information here is not personalized legal advice, it's general information. So it's always best to schedule that consultation, so you get that the accurate legal advice you need to make decisions for yourself and your child, what's best for your child and your family. What form do I need to file for my daughter above 18? So the cutoff age for children that under immigration law is 21. So if your child is under 21, you can still file for them. Now, what form you're going to need is going to depend. I'm assuming that you're asking if it's you as a parent, you want to sponsor your daughter because you're a U.S. citizen or a legal permanent resident. And the family petitions the petition that's used is called the I-130 form. But keep in mind that there may be a number of required forms depending on where your daughter is, what type of process she wants to go through. Is she going through consular processing? If she's outside of the United States, is she going through adjustment of status? If she's in the United States, those will require additional forms. And there's also an affidavit of support form that you also have to look at. So keep in mind that it may not just be one form. It just depends on what process you'll be going through and what your daughter qualifies for. If my spouse is in the military, does that fast track my adjustment of status? No, unfortunately, not necessarily. It could. So for example, if your spouse if there's something going on that's going to affect your spouse and maybe their membership in the military, that may be a basis to ask for an expedite. But normally they will not just fast track it because your spouse is in the military. All right, great questions. Keep those questions coming because I'm here to answer those questions today. I'm both on YouTube and I'm on Instagram. So in the meantime, while I wait for more questions to come in, let me just reiterate the two warnings for you, right? Family immigration and employment-based immigration are two different, they have two different requirements. Now, we're under family immigration if you are the son or daughter of a U.S. citizen under 21 and unmarried, or if you're the spouse of a citizen or you're the parent of a citizen who is 21 or older, you may be able to apply for adjustment of status. That's applying for permanent residence while you're in the United States, even if you've already overstayed. The same applies to VAWA. If you're being mistreated by these relatives, then you could get your status, and not only a U.S. citizen. If you're being mistreated by a U.S. citizen or permanent resident spouse, a parent, if you're under 21, under 25 in some cases, or by a citizen son or daughter. This includes step parents, by the way, step children. If you're being mistreated as a stepchild, if you're being mistreated as a step parent, this could also qualify you. If you're out of status, you could still qualify for relief to get your status here, your work permit, and your green card, even though you may have overstayed or even crossed the border without permission. Those are some of the exceptions to the rule. However, underemployment, if you have been working without a permit for more than 180 days, then you could be in trouble in your adjustment of status application. If you have overstayed, you're definitely not going to be able to apply for adjustment of status. That's a green card while you're staying in the United States. Those are just two of the most common mistakes that I see people make is after they overstay, that's when they say they have an employer who wants to help them to fix their status. What does that look like? Well, the employer can't help them to fix their status. And if any employer is telling you that they can get you to stay here and help you to get your green card, just overstay, it doesn't matter, they can help you to fix it. You need to question their motivations and get legal advice about your rights and how you should be approaching the situation, preferably before you end up overstaying. Unfortunately, I did have a consultation with one person where she came on her visitor's visa. And when she came, they suspected she was working without a permit because she had maxed out her time, her visitor's visa the year before, and they accused her of working in the US on a visitor's visa. Anyway, they gave her a chance and said, you have 1 week in the United States. Well, when she came, she ended up getting a job at an employer, and the employer told her that it's fine. And actually, the employer told her 2 weeks really means 4 months. So, or a week really means 4 months. So if if the immigration office gives her a week to visit and leave the US, she can really stay for 4 months. Of course, that's not true. And she ended up depending on what the employer was telling her, and she ended up overstaying. So there is questionable conduct on the part of the employer, because the employer used fraud, use a type of fraudulent statement to get her to stay for their benefit to continue to work. So, just be wary of that there are rules. And so the two that you need to think about is if you're ending up working without a permit, that's a no-go. If the employer is pressuring you to work without a permit, there's no way you're going to successfully go through the process disclosing that you're currently working for an employer without the petitioning employer without a work permit. And then the other is, if you end up overstaying, then just getting your green card here is going to be a no-go unless you qualify for relief, like a T status as a victim of labor trafficking, which that happens where they're coerced into working, or they're fraudulently induced to work for an employer who has promised them this, and they believe the employer. It's hard for one to understand that they are not able to work without a permit unless they have experience like me and they have knowledge of the law. So that's what I'm here to educate you about, is the fact that those two are red flags for unemployment, and it's going to basically kill your ability to get employment-based green card if you're doing those things. How long are the EADs taking after biometrics? I wouldn't have after biometrics. It's all over the place. But, and it depends on the type of petition that you're filing. I've seen anywhere from 3 months to 12 months. Quick question, how long is taking for USCIS to approve I-130 from now? I'm seeing an average approval time of around 9 to 12 months. So Bali Luke, let me see here. Maybe it's in the question. Do you need your spouse to complete your adjustment if they are slacking off? Now, if they're slacking off, that's usually an indication that there's a bigger problem here. Because anytime I'm dealing with spouses, the both of them are very engaged, because the both of them have each other's interest in mind. They care about each other, and they want usually the US citizen spouse or the permanent resident spouse wants to see it through to the end. And so if they're slacking off and they're not doing their part, you need to evaluate whether you need to come to terms with the issues in your marriage, and then determine whether those issues could qualify you to apply on your own. You can always call and schedule a consultation. Now what I'm referring to is VAWA. If a spouse, sometimes spouses can use this as a control mechanism. They will not file the papers. They'll tell you they're filing it, but they won't take it seriously because they realize that if you do get your papers and you succeed through the process, that they'll lose control of you. And so they're purposely sabotaging and delaying the process. If this is a part of the larger problem that you're facing in with your spouse and you're being mistreated, it could be verbally, it could be mentally, it could be emotionally, could be financially, if they're financially draining you. I've seen situations where the spouses, they constantly take money and say, I need the money to go file the papers. I need the money to go do this. And they come back to you repeatedly. You spent a couple thousands, giving them money, saying, thinking they're going to deal with the papers and they haven't. That's a form of financial abuse. So if you're in a situation like this and your spouse is just not helping you out, you need to evaluate whether you can do it on your own, and it is possible to do it on your own. Can someone file for their mom and spouse at the same time? Yes, as long as the mom and the spouse qualify. And, keep in mind your income. You need to be making sufficient income to support both your mom and your spouse. So if their process is going through at the same time, your income won't be a problem. What's next after you receive a receipt notice for a VAWA case? So you could be scheduled for biometrics, or you get a reuse notice for the saying that they're going to reuse your fingerprints. And then after that, sometimes the prima facie comes within, I've seen it come as early as 2 months, and I've seen it take a couple of months. But the prima facie, if they do say that they believe you qualify, they'll issue a prima facie. If they need more information, they'll send what's called a request for evidence, and they'll indicate on that request for evidence what they need from you. And then after that, depending on whether you filed an adjustment of status application, you would then get your work permit through the adjustment of status. Work permits are taking could be anywhere from 6 months to 12 months. I have seen it come in as little as 4 months. Great questions. Keep those questions coming. I'm here to answer those questions. Thanks for the love. I appreciate it. And on YouTube, thanks for your questions, and keep those questions coming. I'm here to answer your questions. Now, if you already know you're listening and you know you need personalized legal advice, where I would say it's urgent, you must get personalized legal advice, is you are about to take actions. You know you're going to apply for something, you know you want to apply for something, or you need to figure out what you qualify for, or you know you're about to take some kind of action. If it's even, the fact that you're thinking, can I even stay? Can I stay and apply for my green card? These are things that you need to ask before you actually do it. While some people are lucky enough to have options even after overstaying, others end up overstaying first and then finding out that they have very little options. So before you do anything, get in touch, schedule that consultation. It's completely confidential. That consultation, what we say in it, it does not go beyond the office. So that is the time you want to definitely, run your thoughts by the attorney to figure out whether, for the attorney to advise you on what your next steps need to be. All right, so I see my wife took her original marriage certificate with her at USA with her to get the legal process started, but whenever it comes to the time of my visa interview at the US Embassy in the country, then I am required to bring original certificate. Yeah, so that's definitely a green card tip. You should be carrying your originals to the interview. Whether you're doing an adjustment of status or you are doing the interview at the embassy, you will be required to take certain documents, especially your civil documents, the originals or certified copies. So if you don't have the original, you can always order the certified copy. If it's gonna take a couple weeks, make sure you get on it right now to get that certified copy. All right, so that's going to be it for me today. I will be back tomorrow, be back on track again to talk to you about your questions and also come with a good topic to talk about. If you want to hear a topic, go ahead, and if you're watching this or as soon as I come off, go ahead and put the topic you want to hear me talking about in the comments, and then I will definitely make a list and start to talk about those topics that you want to cover. So you can always go ahead and add it to the comments, and then I will, over the next few weeks, I'll definitely address those topics. If you're watching this on the replay, feel free to put it in the comments, and I will read over those, make a list, and then address it. So go ahead, bring your questions or put those topics in the comments, and you can do this on YouTube as well. Put it in the comments. What do you want to hear me talking about? And I will get to it. All right. So have a good evening. I will see you tomorrow where we'll continue to have a good conversation. I'll come with a topic, you come with your questions, and then we can go from there. All right. Thank you. Have a good one. Bye-bye.